the final story of the day that I'm going to be covering. Now, this is a story from the LA Times. The Supreme Court is poised to deal a sharp blow to the unions that represent millions of teachers and other public employees, announcing Thursday that it will consider striking down the mandatory fees that support collective bargaining. The justices will hear the case of Mark Janis, a Illinois state employee who is objecting to paying fees to a union, which represents 35,000 state workers. The decision due by next June could prove a costly setback to public sector unions in 22 states, including Carolina, where such fees are authorized by law. Labor experts have predicted that a significant percentage of employees would stop supporting their union if given a choice. The other 28 states have the right of work laws that forbid requiring workers to join or support a union. Now, the argument that is actually being presented by Mark Janis in this particular case is that he is appealing the lower court ruling that rejected his claim that such fees violate his free speech rights under the U.S. Constitution. Now, what is being stated by the union is actually these powerful interests want to gut the last remaining checks on their control, a strong and united labor movement that fights for equity and opportunity for all, not just the privileged few. And this was stated by the AFT president, the American Federation of Teachers, that is the union that is also a part of this case. Okay, so I think actually what Mark Janis is referring to is a previous Supreme Court case that actually happened several years ago. He's talking about in campaign finance laws when it comes to money equals free speech. And I know that I think another person had actually brought up some pretty good points. Kyle Kalinske from Secular Talk had made some excellent points about this, where in his mind he's sort of viewing the situation as though he should be entitled to make free speech as though it equals money. So if he contributes to this union, he's feeling like he is supporting the union, where he also feels like if he doesn't necessarily have to contribute to the union, he can also just deal directly with the corporation. He should be able to, in the vacuum of that argument, he is stating that money should equal free speech, and that is not necessarily the case, because you can then virtually argue that point for pretty much anything. Whereas, if I contribute some money to, I don't know, some drugs or sexual services or something like that, then that should be the equivalent of free speech, and it shouldn't be a crime. I can potentially set up a bounty on somebody and, request that they be killed, and that should be the equivalent of free speech. That's not a crime. It's all good. I shouldn't be held accountable for my actions. So I don't think that actually works. But I also have a big problem with people who don't necessarily understand the contributions that are made for unions. So they like to bring up the point where they don't necessarily feel as though like they're put in a situation where they're given a choice to be able to join the union or not. And I'll bring up an argument that actually has been done, and this is actually during the Carter v. Carter case. Now, as stated, the effect in respect to wages and hours is subject to the dissentient minority, to the will of the state majority. To accept in these circumstances is not to exercise a choice, but to surrender to force. The power conferred upon the majority is, in effect, the power to regulate the affairs of the unwilling minority. This is the legislative delegation is in the most obnoxious form, for it's not even delegation to an official or an official body, to the private persons. A statute to which limits or confers the power that undertakes as intolerable as unconstitutional interference with a personal liberty and private property. The delegation is so clearly arbitrary and so clearly a denial of rights safeguarded by the Due Process Clause of the Fifth Amendment, and it is unnecessary to do more than to refer to the decisions of this court which foreclosed the question. Now, this is actually an argument in favor of the right to work laws. And here's what I have a problem with this situation. So what they're stating is that the decisions that are made by the majority, to which this is a collective bargaining, is therefore overriding the decision making of the minority. Except, and he also brings up a point later on where he's talking about, and I'm trying to make sure that under these circumstances is not to exercise a choice but to surrender to force. Now, it doesn't necessarily matter whether or not the union was actually there in the first place. There are a set of circumstances that you would have to adhere to, regardless of whether or not the union was there in the first place. So, if a union was not present there to be able to, for you to participate in collective bargaining, you would be subject to being forced to negotiate your wages directly with a corporation. Corporation, which, depending upon who we're talking about, employs hundreds to thousands and potentially, I don't know, maybe millions. I don't think there's a real corporation necessarily that big. Well, there probably are a few, and it puts you in a very lose-lose situation where now, instead of you having the backing of a huge collective of people and a huge monetary source to which you draw from, and people who are looking out for the rights of you, to which you are claiming that you're saying that you are a minority, you are then saying that as a minority your rights are being trampled on. And actually what the union does is the exact opposite of it. The union is actually a representative of you in order to fight these corporations, because they are aware that these corporations have a huge pool of money and resources and a lot of legal power to be able to push virtually whatever the fuck they want. And you, as a minority, don't necessarily have those same resources, but you're equivocating them as if they are the same. So while you're saying that you are a minority and your rights are being trampled on, it's actually the opposite. They're actually working on the behalf of you to bring about better, higher wages and better labor laws for you. So I don't necessarily buy that argument. That the way it's framed is those that it's not necessarily giving you a choice. There is actually a choice in a situation. The other choice is that if you decide to reject the union protections, then unfortunately you are on your own, subject to whatever the whims of whatever fucking corporation that you are working with, be it FedEx or, I don't know, TI or whatever, and they decide to act one way or another on you. You don't have any protections because you decide to negotiate with the corporations. And what the hell are you going to do? You're going to fight in court for years upon legal battles with them. You don't have that kind of backing. And this is the point of what a union is all about. It is to fight on the behalf of the minority, but you're framing it as though they are overriding the rights of a minority when they are in fact fighting for the minority. Now, I am a little bit wary though about this case in some parts, because it was also reported that Gorsuch is also scheduled to speak at a conservative group at the Trump International Hotel, and progressive groups are intended to protest this appearance. Now the judicial branch is supposed to, in practice, act separately from the Trump administration. So the fact that Gorsuch is still this tightly wound into the Trump administration, it gives me the idea that there is some huge political underpinnings that are going on around here that I don't necessarily feel very comfortable with. I hope that in part that whoever is listening to this takes into consideration my arguments and takes it to the case, and hopefully we were able to protect the union laws actually for those teachers out there.